prepared to go forward because preparing my argument was really pretty easy. I have in my hand, Judge, a transcript of your decision the last time we were here, and I have the Randall case. And that's really my argument, Judge. I think in looking at the court's analysis of this back in April of 2024, there's not really anything different here, in my opinion, in terms of how the analysis comes out. And I mentioned the Randall case, obviously, because what is different now, we do have 3 doctors all saying that you should grant conditional release here, but as the court pointed out last time, and as Randall indicates, the court is not bound by the conclusion that the experts have reached, even if those opinions are uncontroverted. So certainly the court has to make up its own mind as to whether or not the evidence at this point indicates a substantial risk of bodily harm to herself or to others. And last time, Judge, you started your analysis looking at the factors as they're set out in 971.17 sub 4 sub D. And after it indicates the court shall grant the petition unless it finds by clear and convincing evidence the person would pose a significant risk of bodily harm to himself or herself, the statute indicates the court may consider without limitation because of enumeration, number 1, the nature and circumstances of the crime. That's where you started your analysis last time, Judge, and it's the state's position that this offense alone is enough to demonstrate by clear and convincing evidence that there's a substantial risk here to others and to herself. The court pointed out that this was a brutal attempted murder. The effort to stab somebody 19 times. But then she's not dead, but then they leave, of course, with the idea or thinking that she'll bleed to death. You know, when I think about this, Judge, I can't help but thinking most people in society are not capable of committing the offense that Morgan Geyser committed. Most people are not capable of taking a knife and plunging it into someone else. One time, Morgan, as we know, did it 19 times and then left this victim to bleed to death and walked away. So, again, the state's position is the offense alone is enough, Judge, to find that there is a significant risk. I know Dr. Collins indicated that certainly the underlying offense is a factor. I think it has to be a huge factor when you're tasked to consider whether or not she represents a risk of substantial bodily injury. The court then went on to analyze the situation by looking at her mental history and present mental condition. And I think that also is still, Judge, very much up in the air. And I'm not saying it's necessarily up in the air because she's experiencing psychotic symptoms or she's delusional. Those things aren't present. But as the court indicated last time in your decision, Judge, we still don't really know why Morgan Geyser committed this offense. And we've had different reasons provided over the years. The court pointed out the diagnosis initially was, or the rationale was Slender Man. And the diagnosis was schizophrenia. Then we have Morgan indicating at some point that I believe it was shortly before our last hearing in April of 24, sometime in 2023, that she faked all of these hallucinations. Really, as you indicated, really the groundwork for the schizophrenia diagnosis, and she made it up. Then the explanation, I guess, shifts from Slender Man to trauma-related from sexual abuse by her father. And the sexual abuse is used, I guess, to go two different routes. One, the trauma from that was such that she lived in this fantasy world, or the trauma was such that she felt her only way out was to commit an offense as horrendous as this and be removed from the situation. We're not really sure which of those two reasons is at play here, but that was the explanation offered. And now, apparently, she's backed off the claim that she made this all up. And now, again, I think we're in a position where we really don't understand it. In looking at the doctor's reports regarding this, I guess I would first go to page 4 of Dr. Robbins' report, where he tries to address this and indicates in the middle of the first paragraph on that page, I believe the only reasonable explanation is that either he is experiencing psychotic.
Order you want?
This is 4 of Dr. Robbins'
All right.
report. They existed in my mind, but they were clarifying the previous statement that she feigned psychiatric illness. She acknowledged it has been difficult to understand her illness circumstances due to her that still doesn't give us any explanation. During her adolescence. In combination with periods of dissociation, she acknowledged breaks in her reality attachment. Again, that what she report, I guess, on page the 6th paragraph that begins in used from the external threats in the environment. Ms. Geyser acknowledged the use of the fantasy world appropriately to process and cope with stressors and questions and pain. But again, there's no indication organ stands on in the while it is this examiner's opinion to a reason that facts weigh in Geyser's placement on conditional release, such consideration that she has never experienced auditory hallucination. To our hearing in April of 2024, that perhaps this court may be more if it had never had these symptoms, if she indicated she made them all up, an attempt to convince the court that she was never schizophrenic. Now, this time, Dr. Lundbaum and all 3 doctors seemed these doctors all schizophrenic diagnosis usual that someone who is schizophrenic is psychotic medication such psychotic here and have not come back for any of that. Who indicated the credibility of the reporter is critical. And I still think there's credibility here. The other analysis, the other fact 17 sub 4 consider where the person will live, how the person himself, what is available to ensure is the next logical.
Ms. Geyser goes all the way back to when she did a competency evaluation very early. And last time Dr. Lumbaum testified, the state called her last time as well to meet their burden of proof. She indicated that she did not support release. So what does the state do now in January of 2025? They call Dr. Lumbaum again. And now their witness takes the stand and testifies under oath that based on her deep analysis in this case, understanding the statutory criteria that needs to be considered, she cites it on page 1 of her opinion, the state's own witness testifies in support of conditional release. And I think almost everything Mr. Sapakowicz just said is a red herring to get this court to be scared somehow into doing what I think is the right thing to do and what the doctors believe is the right thing to do. We can never change the crime. It was a horrible event that took place, a horrible act that Ms. Geyser committed. That she recognizes was horrible. She's talked about it at such length with her therapists and counselors. It's been the theme of constant discussion, and we absolutely have no doubt in this history of this case that there were and was psychotic conditions that she exhibited that explains the behavior, no doubt. Now, and that's because there's a confluence of opinions, a unanimity of opinions among all the professionals who evaluated her in close proximity to this offense who agree on that. They agree on it because including Dr. Lumbaum and Collins and Robbins, because they've been a part of Ms. Geyser's life for over 10 years. And all of them agree, and the state's casting a broad brush here, but I think it's far more nuanced than the way they're characterizing it, frankly. We are dealing with childhood schizophrenia, which is, as every doctor has said, both in their reports and testified to at various times, it's a very difficult condition to precisely diagnose. And they did diagnose it, and they identified it. And there's no question that Ms. Geyser, as a result of those delusions and that trauma, committed this horrible crime. No doubt about it. I don't think the state stipulated to that when they agreed to the NGI finding. And it explains the behavior. The question becomes for this court today, when they attempt to meet their burden of proof, the question becomes whether they've shown by clear and convincing evidence that today, as you look at Ms. Geyser sitting here in court as an individual, whether she still presents that same risk today. She doesn't. She doesn't. Their own witness that they called explained why she doesn't. And what Dr. Lumbaum indicates is that the evidence does not continue to support that conclusion that she poses a risk of bodily harm to herself or others if conditionally released. She offers that opinion to a reasonable degree of professional certainty. Dr. Lumbaum notes that Morgan is 22. She comes to the court still committed to the Winnebago Mental Health Institute, and she describes how since 2021 there has been no attempt whatsoever for Ms. Geyser to injure herself. It was the last time, one and only time that there was any concern regarding her suicide attempt was October of 2021. And Dr. Lumbaum explains this isn't a situation where this is a wishy-washy doctor or somebody who's not confident or hasn't put a lot of thought or effort into their analysis. This is a doctor who explains exactly why she didn't support it in March, but supports it now. She explains that one concern she had back in March was that there was episodic display of heightened emotional distress in the absence of clear provocation or context. And there were concerns about trauma and intrusive memories. What she noted is that since the last petition, Ms. Geyser has been on the minimum security unit at the facility. She's been consistently placed in the pre-integration phase of treatment since June of 2022, which is the highest level of the highest level of permission available. She's earned all the privileges available to Winnebago mental health patients. She's acquired full escorted liberty privileges in February of 2024. She's participated in staff supervised off-grounds activities since March of 2023. And all of the available information, she notes, Dr. Lumbbaum notes, reflects that Ms. Geyser has demonstrated, quote, consistent rule compliance. Now contrast that just for a minute against Randall. I don't know the case. It was a big case in Waukesha County, as I understand it.
Well, it's still a big case, actually, across the state. But since we're citing it again, it's at 211 WSAP 102. That's the citation to it from 2011. But go ahead, just to put that in context.
It is a big case.
Yeah.
And what I meant by that remark was that it was a Waukesha County case specifically, as I understand it, historically. That was a very big case for the community, and it remains a published decision, as you know. But contrast what I just read in Ms. Geyser's behavior against Mr. Randall, who, while he was at Winnebago, the court noted, I think it was Judge Dreyfus who presided over the conditional release hearing, noted that while institutionalized, Randall was secretive, lied to staff, breaking rules when it situated him, and his behavior while committed mirrored the behavior that he exhibited in the community. And what Judge Dreyfus noted and the Court of Appeals emphasized in the published opinion that Your Honor cited was that Randall's secretive behavior throughout his years of commitment, throughout all those years that he was at Winnebago, included hiding items above ceiling tiles at a bicycle shop at Winnebago, denying that the items were his. The court noted that that was very similar behavior to what he exhibited during his original crime spree, because as I understand it, he engaged in a crime spree where he hid a CPR dummy above the ceiling tiles of a high school during a burglary. And when Randall was confronted about these things, he would become agitated and angry with the staff. The trial court made other findings about rule violations and inappropriate behavior throughout his time at Winnebago, failing to report to the treatment professionals that he had inherited money in a trailer, purchasing real estate for $42,000 with his inheritance without revealing that, hiding illicit items of property he purchased, receiving mail without the approval of his supervisors, maintaining a secret bank account, only revealing ownership interest in a property 14 months after he purchased it because he believed that he had been cheated out of $70,000, lying about turning over his keys to his property, lying to his supervisors about receiving mail about the property, violating conditions of his off-ground work privileges by going to his property in a restaurant without permission. And he was aware of all these rules. And it was based on those findings that were in the record that the state put in, that Judge Dreyfus could conclude reasonably that Mr. Randall was being devious, secretive, and essentially deciding he'll do the things he wishes to do regardless of the restrictions or limitations of Winnebago. And Randall himself didn't dispute the fact that he violated the rules on innumerable examples. He just argued they didn't matter. They're not significant enough because they don't involve violence. But what the court noted was you just keep breaking the rules, even when you're in the institution. So I think when you're examining whether they've met their burden of proof and they've called nobody from Winnebago to testify at all that Ms. Geyser has been anything other than an exemplary model patient, and our witnesses substantiate that fact and we don't have a burden of proof, it's far different, far different than the Randall case. Now, there is, of course, the principle in the Randall case that Your Honor cited last time, that if 3 doctors or the multitude of doctors support a particular conclusion, this court is vested with ultimate power and decision-making authority. Nobody's harboring any delusion about that fact, Randall's decision or not. But the question legally is whether they met their burden of proof by clear and convincing evidence. And what you have in this record here is an incredibly thoughtful and thorough opinion by Dr. Lundbaum, where she has examined that history at Winnebago with Ms. Geyser, which has been perfect. We know, and you have in personal knowledge, Your Honor, of Ms. Wyer's case, the co-defendant, you have personal knowledge in this situation of what happens in conditional release hearings, not just from that one, but from other cases you've presided over, and you know how the process works. Once the court approves conditional release, the facility will have 60 days to put together the plan with the treatment professionals in the community, WCS and DHS. And they'll put together a plan, and they will identify the group home for Ms. Geyser to live in. That's what they do for people who aren't going to go home to their parents. Put them in a group home. And you don't have to approve that. You can reject it. You can look at the plan they put together and say, I don't think a group home that they've identified is suitable, and I don't think these conditions make sense, and you can modify that or reject that as you see fit. But to trigger that process to occur requires you to grant conditional release. That's why this is so important. It's important because Ms. Geyser continues to demonstrate throughout her time at Winnebago consistent adherence to the rules of the facility. And as Dr. Lundbaum is noting, and as every doctor notes, and every person at Winnebago noted, that Ms. Geyser will be placed in a group home and supportive environment. She will be closely supervised by staff as she reintegrates into the community. And as you know from Ms. Wyer's case, there will be GPS monitoring. She'll be on a bracelet that will undoubtedly be ordered, and it'll be ordered so that Ms. Geyser's whereabouts are known 24/7. So that was the state's expert. The one witness they called to meet their burden of proof testified contrary to the arguments that they're now making, which is that Ms. Geyser should be essentially indefinitely detained in the facility, because it seems to me that none of these arguments will change. And Ms. Geyser herself has truly maximized the services available to her at Winnebago, and she's shown through her performance that she's not a risk. But it's not just Dr. Lundbaum. It's Dr. Robbins, who's the former director of Mendota, and I don't know who the experts were in the Randall case, but you do have to look at you do consider as part of this analysis who the experts are that are called to testify. There's different levels of doctors and professionals and caregivers in society. Some doctors are new, some are inexperienced, some don't do a thorough job, and then there's others that are immensely qualified. There's a wide range, just like there are of lawyers and other professionals. So last time we were here, 2 of the 3 doctors didn't support release, although Dr. Collins was close. She wanted to see additional positive progress by Ms. Geyser. Dr. Robbins, who is the second witness to testify, is the former director of the Mendota Mental Health Facility. And he evaluated Ms. Geyser, he studied the history, and he also supports release. He concludes that she's not a substantial risk to herself and others based on his study of the history. I think probably I hate to rank witnesses, but I think in terms of length of the report, Dr. Collins' report was certainly the longest. You have personal familiarity with Dr. Collins in countless cases where she's appeared in front of Your Honor. And you do bring that to the table when you evaluate this situation. You consider your life experiences, you consider your history with Ms. Geyser, with the co-defendant, and also your familiarity with the doctors. Dr. Collins is the gold standard, if you will, of psychological evaluations. She has incredible experience, dozens of years working in this field. She runs behavioral consultants. She's the head of the Wisconsin Forensic Unit. This is a doctor who, by all accounts, I think even the state would agree, the state will frequently use Deborah Collins for its purposes. But Dr. Collins endorses Ms. Geyser's release to conditional release. When you read her report, I don't want to belabor it, but we went through it item by item, Your Honor, and Dr. Collins went through the full history of everything that's happened in this case. She went back through the competency evaluations, she went through the medical records, she read the summaries, she talked to the people at Winnebago, and she reached a conclusion that Ms. Geyser is no longer a substantial risk of violence to herself and others. Part of that is, as Ms. Nicolai pointed out when she called their first witness, there are some tests, the HCR test, for example, that they use to help shape their opinions. But it's also, Dr. Collins' opinion is also the product of her long history with Ms. Geyser, interacting with her, talking to her, working with her. And I thought it was significant that Dr. Collins talked about Ms. Geyser's incredible insight that she has into both why the crime happened, as well as what her needs are in the future. We cited some of it when we were talking to her on the stand. If you give me a minute, Your Honor. When she asked Ms. Geyser about her symptoms and whether there was any malingering, Morgan said unequivocally that she was delusional and thus psychotic years ago. And whether those symptoms were triggered by schizophrenia or trauma, the way you figure that out is exactly how Kayla Pope, the medical director of Winnebago, proposed addressing it. A person is medicated, they've been stable for a sufficient period of time, and we start to wean them off medication to see whether or not the condition has gone into remission or resurfaces. If it resurfaces, resume the medication. If it doesn't, continue on the positive track that we're on. And that's far different than Randall. Far different, because as I recall the decision pointing out, there was a finding by the court that there was no mental health explanation for any of this. And the crimes weren't even attributable to mental illness, unlike here where they are. And he received no treatment. There's a guy who goes to Winnebago for a decade plus and he gets no treatment. And nothing had changed except the passage of time and repeated rule infractions. And that's far different than Ms. Geyser, who went through a battery of treatment, antipsychotic medication for years, and has been willing to participate and has participated in every interview and evaluation that's taken place to determine what her needs are. And you look at Ms. Geyser's continued performance, unlike Randall. You look at Ms. Geyser's performance of working her job at Winnebago, being honest with the treatment providers. You heard from her therapist, who Morgan meets with in a one-on-one private setting. And the therapist described, even in a one-on-one setting, Morgan is highly engaged. She's inquisitive. She asks questions. She works on her assignments. She does the things that she needs to do to better herself. And during the outings that have happened in the community, you have a whole list of infractions by this Randall individual, and the exact opposite with Ms. Geyser. She's going to Target, she's going to Pick and Save, she's going to McDonald's and Starbucks. These are escorted outings, of course, but there's plenty of opportunity. If a person is not functioning properly, plenty of opportunity in these outings for somebody to create a scene, to act out, or to do anything to disrupt the privileges that they have. None of that has happened here. Ms. Geyser's in good, so the question is, the legal question for the court at these hearings is whether the state met its burden of proof with the evidence it introduced today. And it didn't. It didn't, not by a clear and convincing standard or by any standard. The evidence that's come in at this hearing today is that Ms. Geyser is not a substantial risk of presenting great bodily harm to herself or others, or property damage. Even after Your Honor denied her release last time, and she was met with the stark reality of the fact that she was going back into custody, back to Winnebago, and had a minimum 6-month period of time before she could even file a petition, she handled that stressful encounter perfectly. She continued with her therapy, continued with her outings, continued working, and worked on her RAP plan, which also demonstrates her ability to understand her condition. You know, when the state argues that Ms. Geyser there isn't an explanation. There absolutely is an explanation. And in fact, Ms. Geyser herself has developed a wellness recovery action plan that she discussed at great length with Dr. Collins. And Dr. Collins noted, she quoted Ms. Geyser about saying that, I acknowledge and understand the gravity of my past actions. This isn't somebody who doesn't appreciate the wrongfulness of what they did. She does, looking back on it, appreciate that. And she struggled for years to forgive herself for what she did to as she put it, the only person who cared about her. And Morgan has completed all of the treatment that's available to her at the institution. There are no greater levels of privileges that she can exhibit. She is a young adult who ought to continue growing in the community. It will make the community safer. It'll make her safer, and it'll make the community safer for her to be out of an institution with acutely mentally ill people so that she can start to grow as an individual. She will be highly restricted, so it's clear. Highly supervised, GPS monitoring, living in a group home. Any misconduct, as you know from your experiences, any misconduct, judge, immediately gets brought back to court. A hold gets placed on her, she goes into custody. If there's even the slightest deviation from the rules and the requirements that are expected of her. But she's shown through her time in Winnebago that she can do everything that is expected of her. She is not behaving violently. She's not injuring herself. She's participating in treatment. She takes her medication. And what Dr. Pope decided to do, I don't know if it's her decision directly or she oversaw it, but the treatment team decision to wean Ms. Geyser off of the medication to see whether the condition was in remission and whether she could be safely supervised without heavy antipsychotropic medication turned out to be the right call, because Ms. Geyser responded favorably to that and continues to respond favorably. Now, do we have 100% certainty? Of course not. That's why the close supervision is important. I would just end by noting that how different this is from the Randall situation in almost every respect. The quality of the doctors that support it, the unanimity of opinions, the thoroughness of the reports, the individual herself sitting here and the things that she's done to prove herself. In the record that's in front of you, the record that the state put in the Randall case showing the pattern of deviousness, dishonesty, deceptiveness that mirrored the crime, justified Judge Dreyfus's decision. No question about it. But this record is devoid of that. Thank you.
All right, thank you, appreciate it. Then Attorney Zapakowicz, do you have a rebuttal argument?
Just briefly, Judge, I don't think this is certainly a determining factor, but it seems to be fairly easily swept under the rug by maybe the doctors and by the defense here. We had this offense occurred in 2014, and we have her suicide attempt 7 years later in 2021. So a long period of time went by between when she engaged in this violent episode towards the victim and then engaged in what I would describe as another violent episode regarding herself, which by all accounts was certainly a very serious attempt to kill herself. There were 7 years in between those two events, and to say, well, this suicide attempt was a long time ago, it was less than 4 years ago. So I don't think that can so easily be considered as being so dated that it is not something that the court can consider when assessing whether or not she currently represents a substantial risk. I went back to look at, and I guess I'm unsatisfied, Judge, and I think the court should be as well, from the doctor's explanations of things, because when I look at Dr. Lundbaum's report, and I start at the bottom of page 15 under her analysis and conclusion, section, Dr. Lundbaum talks about Dr. Lundbaum's report prior to the hearing in April of 2024 and notes that in that prior report, she raised concerns about Ms. Geyser's remarkably low understanding of her psychiatric illness, especially given her claims that she fabricated psychosis at the time of and for several years after the index offense, in clear contrast to the abundance of evidence available. I noted that the inconsistency in her self-report over time complicated the prediction of her risk for future violence and the ability to create an appropriate supervision and treatment plan. I guess what I'm unsatisfied with, Judge, is there's then no explanation in this current report how that's not still a problem. There's no explanation of how we get past the prior inconsistencies in Morgan's self-reporting and how over time that affects the prediction of her risk for future violence. Dr. Lundbaum just kind of skips over that and goes into, well, she's following the rules, she's doing well, hasn't caused a problem, and therefore, because of all that, I believe release is now appropriate. But again, there's no explanation how we get past that prior inconsistencies in her self-reporting. So that's all. Thank you.
All right, thank you, Mr. Zopakowitz. I'm going to take about a half-hour recess just to review items, and we'll come back. Let's plan to come back about 3:15. So we'll be in recess up to that point. Thank you.